name's Bridget Mackay. I'm an attorney and I practice in Petaluma, California in the area of wills, trust, and estate plannings. Welcome to my video blog. Today I want to talk a little bit about changing of a will. How many times have you heard someone tell you that a family member or a loved one or a story that they know that their parent, grandparent, aunt, uncle changed their will at the last minute and they were concerned that that person had the capacity to do so because the change was significant. It cut someone out, it cut maybe natural heirs, a son or a daughter out, and went to a new wife or husband. Well, that's what I'm going to talk a little bit about because I've heard a lot about it. A lot of clients have brought up that situation to me recently. And it's a big fear, I think, of those folks who have parents who are either remarried or are suffering from dementia, or they think that they may be suffering from dementia or Alzheimer's or some sort of memory or capacity loss. What does it take to change your will? What kind of mental capacity do you have to be in to execute a will? And essentially the law says it's pretty not vague, but it's pretty broad, and it says you have to have significant impairment of your ability to understand and appreciate the consequences of your action with regard to the type of act or decision in question. So it's not sort of you're forgetting some things, but there has to be significant impairment. They have a list of things to look at: orientation to time and place, whether someone can make decisions on themselves, recognize people, recognize location, recognize numbers. So it's a pretty general description, and often if you're in this situation and you choose to challenge a will that someone has changed and you have a concern that they didn't have the capacity to do so, it's going to rely a lot on the facts. And frankly, according to the case law, the impairment does have to be significant. I think you'd be shocked to know, there was a case where a woman couldn't talk, but could communicate by blinking her eyes and writing, and that was enough capacity for someone to change their will or make a different decision. The other question that comes up is something called undue influence. Oftentimes in these stories, they think that there's some other person, whether it's the stepmom's children or a money-hungry relative, that has undue influence or is influencing an elder person to change their will. In those situations, again, proof is difficult sometimes because you have to show that, number one, the person who's changing their will is susceptible or has some sort of weakness to undue influence. So again, it's a capacity issue. And number two, that that person asserted the influence. And again, proof of that is sometimes difficult and often comes down to whether or not when the second will or the new will was revised, was there an attorney involved? If there was the person who changed their will alone with the attorney and the person you're accusing of undue influencing them was not there? Things like that. So it's a very complicated thing to look at, and when I hear those stories or those concerns, or I meet with clients who have them about a loved one's will, the idea of challenging it is a big question to answer. And so if you know anybody who is in that situation or you're in that situation yourself, talk to an attorney and find out if you even have a case, because it can be long and drawn out and expensive. So those are just a couple of thoughts on changing wills and people having capacity to do so.